Good morning and hello. Welcome to this month's webcast, Navigating the Employee Disciplinary Process. My name is Max Smith. I'm with 501c Services. Today's webcast is brought to you by 501c Agencies Trust. 501c Agencies Trust is the nation's oldest and largest unemployment program. If you're a 501c3 with more than 15 full-time employees, it would probably be to your benefit to go ahead and give them a call and see how much money they can save you on your unemployment program. Many of today's webcast attendees are participants in the 501c Agencies Trust unemployment program, and we thank you guys for attending this morning, and thank you for continuing to work with us. Before I introduce today's panel, I have a couple of housekeeping tips for everybody. First of all, if you have questions, please feel free to shoot those through us throughout the presentation. If you're looking at your webinar screen right now, right below my photo is an Ask a Question box. You go ahead and type in anything you need and send it to us, and we will answer questions as we go, and we will also have a Q&A session at the end. This webcast is going to be available on demand, so if you need to share it with managers, supervisors, friends, and family, please feel free to go ahead and shoot them the link that you used to register, and they will have access to it. It's also worth, today's webinar is also worth 1 hour of HRCI credit. If you attend the entire presentation, we will send you the necessary paperwork at the end of today so that you can get those credits for your PHR-SPHR. We also do this every month, typically the last Monday of the month. We're very fortunate that today's last Monday happens to be on a day that we won't see again for 4 years, so happy Leap Day, everybody. And also, just a quick tour of what you're looking at. If you have any buffering, either in the audio or video of your webcast, if you look right below my picture, there is a refresh button. There's a play button, a stop button, a refresh button, that kind of recycle-looking thing. If you hit that, it should recycle your screen and usually corrects any buffering that you might have. So that's that. And with all of that, I'm going to go ahead and introduce our speakers. Good morning, ladies. How is everybody?
Good morning. Great. Thank you. Good morning.
Good morning.
So with us today, we have Maureen. She's with 501c Agencies Trust. She runs their HR Services Department. We also have Julie. She's an HR executive with Community Bridges. And we have Kai Cha with Littler Mendelson. We'll give their complete bios during their sections. They will have a bio template, as you can see mine, with all of their wonderful accolades of their wonderful careers. So we have a great set of speakers for you today. So with all that done, only took us 3 minutes to get this thing going. I'm going to go ahead and turn it over to Julie, who's going to talk about the disciplinary process. Julie, good morning. Take it away.
Good morning. Thank you so much, Mac. It's a pleasure. I hope everyone's doing well. I'm going to speak about the objectives of what you're really trying to achieve with your disciplinary process. You really want to think about, what is it that you're trying to accomplish? You want to, of course, apply fairly and consistently, take into consideration any laws and policy requirements. Because I work in a union environment, we also look at our collective bargaining agreement, make sure we're following that consistently, and then be sure that you conduct very effective disciplinary meetings. You want to, plan and document appropriately, and make sure that you really are thorough in what you're trying to accomplish. Next, I wanted to speak about the benefits of discipline. There actually are great benefits, as we know. It's an opportunity to establish expectations and really give the employee that very clear and concise areas that need to be corrected. And you want, again, to apply those consequences fairly and consistently, so you have to really be thoughtful about that process. This is an opportunity to correct inappropriate behavior, poor performance, ongoing issues, and give that employee an opportunity to correct with really, the idea of what we need from you and what next steps are depending on how that goes. It helps to rehabilitate employees that have potential. Sometimes you have a great employee, but there's an area that they just need, they really need to improve on, and so this is an opportunity to coach them, mentor them, help them along, let them know what you need. And it also protects you against complaints and lawsuits, which is very important. Again, coming back to the consistency piece. Let's talk about the importance of following the discipline policy, either, say, in your personnel policies, employee handbook, and or in collective bargaining agreement. At Community Bridges, we have both. We have 2 unions and the personnel policies or employee handbooks. So you really have to make sure that you're clear on who falls under which category and which rules apply. The disciplinary policy really provides a legal protection to the employer. It gives structure by being consistent and also reassures the employee. They should know really what to expect and what's expected of them. I know you can't get them to improve if they're not clear on that. They can also, if they look to their handbook or a collective bargaining agreement, they should be able to see really, what they can anticipate for next steps. And it also offers some protection to employees because it gives us guidelines and policies to follow as managers. Disciplinary also gives employees an opportunity to improve, and that's ideally a best-case scenario. It also informs, advises, and there's times, as we know, that it allows for flexibility. So there's that part of HR where it's not always totally black and white. In discipline, there is a lot of very clear and concise guidelines or policies to follow, but there are those areas where, you have to kind of look at the situation. So, yeah, it's definitely very, very helpful. I think that covers my part of the slides, if I'm on track here.
Okay. So thank you, Julie. Maureen is going to dive a little bit more deeply into the entire process. Good morning, Maureen. How are you?
Good morning, Mac, and good morning to all of you that are with us today. And I'm going to talk about that word you heard from Julie, consistency, always very important during the disciplinary process or any area of HR practices. So what is consistency? Why is it important? Well, consistency is important, of course, when applying these disciplinary actions. If you apply them inconsistently, you certainly could expose yourself to charges of discrimination or unlawful termination. So it's very important to thoroughly document this process and any of the disciplinary actions you take with each individual employee. You want to establish a fair and reasonable disciplinary process, and your process should give the employee the opportunity to know the job expectations, fill out the job description, and let them know what the consequences of not fulfilling those expectations are. And you want to have them expect your employees, and predictable management action when those rules are violated. And discipline is really based on the facts, and the fact that you have been fair to that employee and you have gone through a process with them. And you want to you want them to be able to appeal this disciplinary action if that's what your organization allows you to do. And you want to show improvement if time permits. Now, I know most of you are human resources professionals with us today. I don't know if any of you are wearing different hats, but I also know it's very important, as you probably do, to get your supervisors trained in touching base with you to make sure that they're being consistent for similar situations. So take a moment to ask yourself, is your disciplinary action reasonable and based on the normal capabilities of those employees working under similar conditions? Is the employee working at the same expected level as other employees doing the same job? Did you clearly communicate the work rules or the expected performance levels to those employees? Did you take circumstances into consideration? Is there sufficient evidence that exists that the employee violated that work rule or did not meet the performance standard? Did you document this evidence? And did you adequately train the employee so that he or she can be expected to meet the required performance standard? Very important, this is what you want your supervisors to do, is to consult with you and Human Resources to ensure that no other circumstances might excuse that violation. And the penalties, the process you go through, and I'll get to that next. Is the penalty reasonable and appropriate for the particular violation? Did you give the same penalty to the other employees in similar situations? And did you treat other employees the same under similar circumstances? That's very important, such as attendance issue, absenteeism. We get a lot of those calls on the hotline. You have Mary who has gone beyond what her policies have said as to what's considered excessive absenteeism. You've counseled Mary. You have found there's a poor pattern of her being out every Friday, Monday. And you've gotten to the point where you feel you've been fair to Mary. You've gone through a process and you have had to make the unfortunate decision to have to terminate Mary. Then you find out later on, and Joe knows this, or Mary knows this, that there's another employee called Joe who's been out more than Mary and has definitely broke those policies in regards to the attendance policy, and no one does anything about Joe. You don't want that to happen. That would give Mary some fuel as to whether she had something if she decided to be litigious. They have to be very careful, very important to be consistent. But it's only fair, too. You want everybody to feel like they've been treated the same for similar violations. Now I'm going to go on to the progressive discipline process. I don't know how many of you, of course, have a disciplinary policy in place, and I'll talk about the pros and cons also. But most of us would start out with what is considered the verbal warning of that first violation of a rule governing work behavior or performance. And this verbal warning will alert that employee to the existence and nature of the violation. And you also want the employee, allow them to respond, to hear what they have to say. And hopefully that verbal warning is just the only step you have to go through, and it takes care of the situation, whether it's performance or behavior. And it should develop an agreement on how to correct that behavior. If this does not work, then you probably go to step 2, that written warning, following that verbal warning. And this would emphasize the seriousness of the violation. And step 3, maybe you go to suspension where you feel it's more serious. And this serves as a last resort before the discharge. And that may be in your policies too, or you're investigating a situation and you want to put somebody on administrative leave while you're investigating. And hopefully not having to go to step 4. All the rest of those steps will have taken care of that situation. And of course that would follow all the other disciplinary steps. So that's what's considered the 4 steps of progressive discipline. That's the type of policy you have in place. Now there's pros and cons to that. A progressive discipline policy, as I just mentioned, lays out a clear progression of actions that will be taken when an employee violates your work rules. But of course there's other infractions that may warrant skipping the early steps. And of course there may be an immediate reason or policy that says you have to immediately term someone. As with any workplace policy, progressive discipline comes with advantages and disadvantages. And you must consider that before adopting such a policy. And as always, I would always say have legal counsel review your final policy that you put in place. The pros to progressive discipline would provide a clear explanation of the consequences of not following your rules or meeting expectation. It should facilitate consistency and fairness in disciplinary procedures. It should give your employees the opportunity to change behaviors. It should give you also the chance to explain the actions the employee can take to improve the situation and to offer coaching and mentoring. And it should provide you also with alternatives to termination for minor infractions, improving employee retention. And you want it to enhance that morale when employees know you're not going to fire them for a minor issue. Morale can also be enhanced by the knowledge that the poor behavior of others will be addressed. And it provides you with evidence that you gave that employee every opportunity to improve. Now, I know there's cons to this type of policy, because it can seem inflexible. If not followed consistently for all employees, it could appear discriminatory. And you want to avoid that, of course, and that's why I'm saying have the policy reviewed, making sure your supervisors are trained to follow it properly. Also, some other cons, the fear that the progressive discipline policy implies that the steps must be followed before you terminate an employee, which could have the effect of an implied contract stating that the employee will never be terminated without these steps, and feel that might jeopardize the employment's at-will status. But the key to this, and I believe in the disciplinary process, as Julie said, it's fair. It's a good way to show your employees that you care and you're going to go through a process with them. So the key to this is to take measures to mitigate the risks presented in each of the cons. For example, a disclaimer in the policy noting that the steps can be skipped at the employer's discretion and that the policy does not affect that at-will nature of employment. Now, I also want to talk about the disciplinary meeting.
Maureen, can I interrupt you for a second? I had a couple questions about the steps here, mostly around the verbal warning.
Sure.
We're getting a lot of questions about documentation of a verbal warning. Sure. Can you talk about that a little bit?
Yeah, I commonly get that on the disciplinary webinar that I do for our members. And verbal warning, some people say, well, do I have to put that in the personnel file? I don't know if that's the kind of question you're getting. And I say, yes, that's important, and it should be still signed and acknowledged, even though it's the first step. And the employee, you need to let them understand that, too, that it's time to take care of the situation that you noticed was occurring, like making mistakes on reports. And you feel it's time to talk to that person and explain, how that has to change. But you're merely having that conversation with them and putting it, but still documenting it. I still think it's important to document that and have it signed and acknowledged. Are those the questions we're getting, Matt?
Yes, ma'am. You covered it perfectly. Thank you so much.
And I'm sure attorneys today will, yes.
Well, this is Kai. If I may just add, I have employer clients, and we have a form, or they use a form, and even though it's a verbal warning and not a written warning, it's a piece of paper, and on the top it just says verbal warning. And it documents whatever the employee's being verbally, talked to. So I think it's a really good practice to have a piece of paper, to document it, even though it's verbal, and have the employee sign it too, even though it's verbal and not written.
And this is Julie. We do as well at Community Bridges, and it does just like the lady said, and it says verbal warning documented in writing. And sometimes people think that's a little odd, but it's a really good opportunity because, as the other speakers mentioned, it gives you an opportunity to have them sign it, and if they refuse to sign that document, then we try to tell them they don't have to necessarily agree with it. It's just that they've received it. Sometimes that helps if employees are reluctant to sign. Otherwise, we just write on that line they refuse to sign, and we give them an opportunity to respond in writing.
Perfect. Oh, thank you, ladies.
Mm-hmm. Yeah. The disciplinary meeting. Of course, we all would agree we need to conduct those actions in private and without any interruptions. So give yourself a good time for you and that employee. And allow enough time to pursue the issue completely. And, of course, listen to that employee. Listen to what they have to say. Listen to their questions. And never engage in disciplinary action in a public setting. I know I'm talking to human resources professionals today, and we know that would be dangerous anyway, but it is amazing. You need to get your supervisors trained. Don't start talking to that employee out in a public venue. Not a good thing. The disciplinary action should include a private face-to-face meeting with the employee. And here's some tips I've come up with. Always important, never lose your temper in the course of disciplinary meeting. It's easy. You're angry about something or you're frustrated with that employee. You just need to take a deep breath. You need to take the high road. You need to treat them respectfully and not show any anger. Or if you feel like you're out of control that morning, do it in the afternoon. So when you lose control of your temper, you may say things that damage your relationship with that employee, and of course you would later regret that. Not a comfortable situation. Tackle the disciplinary action directly. Do not avoid it. It's hard to confront, but very important. You don't want to go 6 months or a year down the road and never have approached a performance issue or behavioral. Not a good thing to do. It's best to get into that situation right away. Avoiding disciplinary action may actually harm an employee who is deprived of the chance to learn how to correct his or her behavior. That's the whole key here of being direct with your employees. And you do that by going through the disciplinary process and clearly documenting it and having a performance plan with the employee and the goals you want them to achieve. It's only fair. And then they're certainly, most definitely part of the process because they're going to ask those questions. You can ask them to respond back in writing as to how they plan to improve. Never play the therapist. The employee may misinterpret the supervisor's personal questions as being nosy, overall analytical, or an invasion of privacy. And make sure that the employee assumes responsibility for change. Make sure they understand what you're talking about. Ask them questions if they understood and have them respond back to you. By accepting excuses, supervisors will deprive the employee of the chance to accept responsibility for their mistakes and instead allow them to continue rationalizing their performance deficiencies. And Julie had just mentioned this, but of course it's very important to get the employee's signature. Ask an employee to sign any written warning or disciplinary action agreement that's placed in his or her personnel record. Now, that most employees, we can say, probably do not like being reprimanded, so you may want to emphasize that a signature is not an admission of wrongdoing, but instead an acknowledgement that the employee received the warning. If the employee refuses to sign a written warning or disciplinary action agreement, note the refusal on the warning or agreement. So that's my part of the program. I hand it over to our attorney from Littler this morning.
Hi, so my name is Kai Cha, and I'm talking about why it all matters. The first thing I'm going to talk about is consistency, why that matters. And if I'm going to go up to Maureen's slide about the disciplinary process. So in general, while these steps are not legally required, we strongly encourage all of our clients to take these steps with their employees. It's really the best practice. And a lot of that is because for employees, when you fire employees and they are caught by surprise, then there's more risk of hard feelings. And in California, hard feelings often translate into litigation. So the more that a poor performer kind of has notice and knows that their performance is at issue, if and when they are actually terminated from their employment, let's say things don't improve and an employer has to take the step and terminate employment, if it's not a surprise, then often you reduce the risk of litigation. Right. The other thing to keep in mind about the disciplinary process is whatever process that you have internally is as as everybody has said, consistency is the key. And the example of Joe and Mary and the tardies, that's absolutely come up with me in litigation. We had a case where we had an employer, and their policy is to fire new employees if you are late more than 3 times within the first 30 days of your employment. And so they had a low-performing employee. She was late more than 3 times within the first 30 days, and we fired her. I mean, it was like perfectly sort of textbook example of like, this is our policy, this is what she did, she breached the policy, so she was fired. Well, ends up she was sexually assaulted in the first 30 days by a coworker. She complained to her manager about the assault, and then we fired her for being late more than 3 times. So in the litigation, plaintiff's attorney, they said, well, they wanted to see if we were consistently applying our fired if you're late more than 3 times among all of the employees, among all of her sort of peers. And this was an employer with a lot of, they had high turnover. They have this particular plaintiff was a sort of entry-level, she had an entry-level minimum wage job that there's a lot of turnover. We hire a lot of employees in that position. We had to go back for like 3 years and compare all of the schedules against all of the time punch records to check was everybody being fired was everybody being fired if they were late for more than 3 times within their first 30 days. And we found that the policy was actually being applied inconsistently. And I think this typically happens with a lot of employers. Like when you have new employees, I mean, often you will give person A a little leeway for being late because you know that they're maybe commuting in on the bus and they don't have a reliable source of transportation to come to work, or like maybe somebody has they've got extenuating circumstances, maybe they have child care issues, and so you give those people a little slack and you cut these people a little slack. And maybe in this situation with the plaintiff, she had no extenuating circumstances, so she was just late 3 times, so we didn't cut her any slack, except none of that all these extenuating circumstances reasons are documented. And then basically it changed sort of the whole valuation of the case because plaintiff's attorneys, they were going to have all these examples of all these other people who came in late more than 3 times within their first 30 days. And we didn't fire those people, but we fired plaintiffs. And so now we have a pretext argument, right, that the real reason we fired her was because within the first 30 days she complained of a sexual assault of a coworker. She was a sort of a troublemaker, and we just decided to shut that down, and we let her go. We let her go in retaliation for her complaint. So consistency is really, really the key here. The other thing I want to talk about is sort of and this is sort of similar. It's the inadvertent failure to be consistent, which is when you have, let's say, and we were talking about this earlier, but the way it looks in litigation is, and this is another example where we had a 2 plaintiff case, and they were poor performers. They were sort of coworkers, and they were unproductive. We fired them for performance reasons and for their lack of productivity. And the person, like plaintiff number 1, she was like the number 10 highest user of the internet within the company. And plaintiff number 2 was like the number 12 highest user of the internet with the company. So, like IT pulled their records. They were constantly on the internet. I think they were like shopping for shoes all the time. They were on Zappos all the time. Buying shoes, and they weren't doing their jobs. Well, again, ends up plaintiff number 1, she had complained that her manager was sexually harassing her. plaintiff number 2 complained to HR on behalf of plaintiff number 1. We let them both go. The EEOC litigates it. We tell the EEOC, look, this is they're number 10 and number 12 of the highest Internet users in the company. They're completely unproductive. The EEOC then turns around and asks us, well, what did you do about employees numbers 1 through 9 and number 11? Were they ever disciplined for their Internet use? The answer there was no, right? I assume that employees number 1 through 9 and number 11 were able to get their work done along with spending their entire day on the Internet at work. And so what happens when you're sort of inadvertently inconsistent is that it completely changes the value of your case in terms of trying to settle the case, in terms of your settlement dollars. Because now in this case with the 2 plaintiffs, the EEOC, again, well, they have an argument for pretext, right? The reason that you let these women go was not because of their high Internet usage, and it couldn't be, right? Because you never did anything to the employees numbers 1 through 9, the highest Internet users in the companies. Numbers 1 through 9 were never disciplined at all for their Internet use. So obviously the only reason or one of the main reasons you let these women go was, again, for retaliation, for complaining about sexual harassment, for being the one to actually complain about the sexual harassment and then to complain on behalf of your friend that she was being sexually harassed by her manager. All right. So that is why in litigation consistency and following your disciplinary process is so important. The other place where being inconsistent hurts and where I've seen it, again, the inadvertent inconsistency is we had a situation where a vendor made a complaint about a particular employee. We investigated it, found out the employee was performing the wrongdoing, and so then we fired her. Well, in litigation, the employee came back to us and or her counsel came back to us and said, look, 2 of her coworkers were doing the exact same thing. And so what did you do to the 2 coworkers? And the situation with the employee is that she had a disability, okay? And again, having 2 coworkers who weren't disciplined for engaging in the exact same misconduct gave them the argument that our firing the plaintiff was simply a pretext, and the real reason we fired her was because we were discriminating against her based on her disability. Okay. The second point is to talk about the documentation. All right, why documentation matters for litigation. All right, and I know that for a lot of HR professionals, you guys are not necessarily covering, let's say, one office. Instead, I work with a lot of HR reps who have an entire territory, like they have the entire state of California, or they have Northern California or Southern California, right? And so they're on the road all the time, and maybe they work out of an office, or maybe their office space is incredibly small. And so documentation for most people is a huge challenge, right? And I've seen the range. I've seen it where we're in litigation and I request HR records about a particular employee, and I get records for that particular employee. I've had experience where I had one HR rep who I was working with, and her practice was she kept these spiral-bound notebooks in chronological order, and every single employee issue that came up was put in these spiral-bound notebooks. So a spiral-bound notebook that would cover, let's say 3 months, literally just had every single employee issue that she ever dealt with within that 3 months. And so when I would say, hey, I need your notes, and about so-and-so, she would say, okay, yeah, I have to find my notes. And it would be months and months, and I'd keep following up like, Anne, we need your notes, and now plaintiff's counsel needs your notes. And the situation is that she literally had to go back to that time period within her notebooks and go through every single page to try to find her notes about her conversations about that particular employee. And if we had one of the employees had been at the company for like 3 or 4 years, so we literally had to go through every single page of all of her notebooks that cover that 3 or 4 year period to find every reference to that employee. Right. I also have had the situation where there is no documentation. HR has no notes. Right. The employee's been calling. There are performance issues. We've been talking to the manager about the performance issues, and there is no documentation. Without documentation, it implies that any performance issues were not serious. All right, so our recommendation is to keep employee-specific files for litigation purposes. And it's hard to know. I mean, obviously, you guys have many, many employees. Their employee issues come up all the time, and it's impossible to anticipate what is going to end up in litigation. Right? That being said, it's still the best practice to keep a separate file for each employee because you never know who's going to end up in litigation. And our recommendation for this is because when you have an employee-specific file, if it ends up in litigation, it makes the whole sort of preliminary investigation by your attorneys, it makes that go a lot quicker. It helps facilitate discovery. And then when we can produce your files that are specific to the employee to the other side, it helps facilitate plaintiff's attorney's evaluation of the case. So those are my points about consistency in documentation.
Great. Thank you so much, Kai. I don't know about everybody else, but I could probably sit there and listen to Kai's war stories all day long. It's great to listen to. So we have we have questions coming in, but we'll have a little bit of a panel discussion here for about 5 minutes. So if you all have questions, please feel free to shoot them in. We have a couple dozen in now, and we'll try to get to as many as possible. But I wanted to kind of address the logistics a little bit more of the disciplinary process. Obviously, the whole program runs through an HR department, and we know that different size organizations have different HR capabilities. Can you all talk maybe about the best practices of getting the disciplinary process trained to the floor managers, to the supervisors? Because it seems like, especially with Kai's examples, we're seeing a lot of paperwork issues and consistency issues. How can we address those best so that our managers become good managers and don't hurt the organization if we need to go to court or something like that?
I'll start off. This is Maureen. I know with the HR hotline, the key here is getting your supervisors trained for sure. We actually provide some training for supervisors for our member agencies on that process. It's hard for human resources to do everything, so sometimes it is definitely good to get someone from the outside to help you train your supervisors on proper documentation methods and the importance of the disciplinary process. And that is your key to defense, is that supervisor. And the relationship they have with human resources and understanding they can go to human resources when they have questions, and you work as a business partner, a team.
Right. This is Kai. I have to say that I think training your managers on the disciplinary process or getting manager buy-in, it's the hardest thing. Managers, well, good managers will do it, right? But, I mean, The hardest thing for a manager, I think, is to give negative feedback to their employees, to sit down with their employees and point out these are the things that you're not doing well and you need to improve on this. And honestly, in my experience, I've worked with nonprofits in particular who have managers who don't want to do this. And I was working with this one nonprofit that, like, they had different locations all around the country, really, and the heads of each of their locations, they never went on vacation. And they never went on vacation because they could never take a day off because they couldn't trust their employees to do their jobs without them there in the office. And I think part of that was because they were not disciplining their employees when their employees had performance issues. And instead of like sitting down and giving like uncomfortable feedback, they would, if their employees weren't doing their jobs, their managers would just take it on themselves. And so to me, that anyway, if you have, a lot of managers who are never going on vacation, that's a huge red flag that the disciplinary process is not being followed.
I agree. This is Julie, and I think it is, like I said, it's tough for folks to want to sit down and discipline their staff. What I try to coach folks is, you really want to coach the employees to success. If there's issues and you don't deal with them, they may not figure that out themselves. And so you're actually doing them a favor by sitting down, even if you need to start with a verbal and let them know. They may say, oh, my gosh, I had no idea. It gives them an opportunity to correct. And so by not doing so, it typically just gets worse. And I always tell the managers, if it's not documented, it never happened because you don't have that documentation. You haven't had a dialogue to try to help the employee improve. And it's really, it makes it a lot tougher if they wait till things are just really serious. And so I think also with different layers of management, we can't always rely on, like in our group, it's a program director to necessarily coach and train the mid-level supervisors. So we need to make sure that we try to reach all those different levels of management to help them with their supervisory skills.
Perfect. Great. All right. Well, we have a number of questions, so I could pose another question to you guys, but I think we should probably get to the audience now. So I'll just shoot these out, and please feel free to speak up if you have an educated opinion on it. To start, differences, does anybody have any views on the differences between using probation and suspension? I guess it could be, go ahead.
This is Maureen. There's differing opinions on probationary periods or orientation periods, or there's different ways of stating that. And you have to be careful your policy that it also has the at-will in that policy explaining that you're still an at-will employer even though the employee is on probation. My feeling is, why have the probationary period? Start right away when you know you're having a problem with an employee. And maybe they need more training, or maybe you find out, as Julie said, they didn't understand something. Do it right on the get-go from when they come on as an employee. And then if you have the problems, then you can go into your process of talking to them verbally and maybe having to go on further than that. So that's my opinion on probationary. I'm not a big proponent of suspension, but some employers do feel that gives a message to the employee when the matter gets more serious that they need to go think about this, and so you're going to ask them to, give them if they're an unpaid suspension. I say it's better to just go on with your discipline process and maybe go on to another more serious written warning that says if things do not improve, it may be cause for further discipline, including termination. Now, that's my opinion. I think suspension is most important for administrative leave for doing an investigation of harassment or something where you've got to find out, what the truth is there before you make your decision, if possible. That's my opinion on it.
Right. this is Kai. I think suspensions, I would agree with Maureen. When you've got an allegation or a complaint of harassment or some allegation of misconduct, well, when you have an allegation of misconduct, like let's say somebody in finance is embezzling, then you suspend the employee, right? You cut off their access so you can stop whatever misconduct may be occurring, and then you do an investigation, figure out what's going on. So, a suspension is also when you have an allegation of harassment. One of the things in California, at least, that employers get in trouble for is person X is complaining their direct supervisor is harassing them, right? And then even after the complaint, they were forced to work in close contact. They were forced to continue to report directly to them, and the harassment continued all during the investigation. And so you can suspend sort of both people during the investigation, or you don't really want to suspend the complainer though. So you suspend the supervisor during the investigation to remove them, so that the person who is complaining is no longer being, no longer required to report directly to them, report to them, work in close contact with them, that kind of thing.
Okay, great. And both Maureen and Kai kind of brought this up, but I just want to clarify because we do have a question in there about skipping steps. Obviously, if you have something in an employee manual that indicates this is our process and you're trying to be consistent, but I can imagine, and correct me if I'm wrong, if there's a degree of something being done that the employer's okay to skip steps, like maybe skip the verbal and go directly to a written or something like that. Can you talk about skipping steps in your process while still maintaining consistency, or do you have to just maintain the steps?
You have to have. You go ahead, Kai. That's an interesting area. It all has to do with policy, doesn't it, Kai?
Yeah, and well, it's also, it's the degree of severity of whatever the employee is being disciplined for. I think your policy should always give you an out to bypass all of the steps, and then whatever the misconduct is that someone's getting disciplined for, it warrants the skipping steps. But again, your management should have kind of a clear understanding. Right? Like coming in late X number of times is one thing, abandoning your job is another, embezzling money, like harassment or confirmed harassment of other employees. It's all kind of the degree of severity of the misconduct.
And isn't it true? Yeah. And sometimes things are just immediate termination. We haven't talked about that.
Yeah.
But that's also consistency, right? As to what a reason would be that you would immediately term somebody. And then for me on the hotline, I'm not an attorney, so I would send you to an attorney, and to if you had a very highly sensitive decision to make regarding a termination.
Right. And you can, suspend somebody while you're trying to decide whether or not to terminate them when it's like a serious offense.
Right.
Sorry, Julie, I cut you off.
Oh, no worries, no worries. Yes, this is Julie. I agree with everything they said. We have actually, in our personnel policies and in our union contracts, a list of major violations. And if you fall into one of those categories, then we can skip the steps. We try not to jump straight to. What we do is a recommendation for termination during that investigation period, but they're very specific, so that, like you mentioned, Kai, if it's embezzlement or a harassment claim or something like that, we want to definitely investigate it. We put the person on suspension, and what we do is we actually pay them for the first few days during that investigation. Then the CEO determines, does this appear to be valid? Then they go to unpaid while we continue. It's a unique process. It might not be for everyone, but we definitely do suspend to remove that employee in those major violation cases and then make our determination. so that it not very often does it happen immediately. There's a process that we follow, and it gives very specific violations to go to if that happens.
Okay. We do have a couple of questions in the queue that center around being an at-will employer. It seems like a couple of attendees are worried that some of these processes and documentation, it feels like it eliminates their ability to be an at-will employer. Can anybody comment on that?
At-will, yeah, that's always a difficult one. Pretty much all states are at-will, I think, except for a couple, but that's why you have to be careful of the policy you put in place that you don't take the at-will away. But at-will can be dangerous if someone definitely is in a group where you could get discrimination claims, over age discrimination, ethnicity. At-will doesn't work. And at-will will scare me at times because I still think you need to have good documentation and show that you're letting your employee know what the problem is. But I know some employees feel like employers feel like I just can't deal with this anymore. I'm going to say, we're terming you because we're an at-will employer and you're an at-will employee. And that makes me nervous, and I definitely, as an HR professional, would say, go to Kai as an attorney. I really would love Kai to address this. I really would, because it's such a crazy, confusing area.
Right.
It really is.
Okay. So I only practice in California. California is an at-will state. All right. So just to be clear, right, none of the disciplinary steps that in Maureen's slide are required by law, right? But we still think it's the best practice to follow that kind of warning thing because it helps reduce your risk. We think it helps reduce your risk of litigation. In putting in all those steps and doing all the documentation, it does not undermine your argument that an employee is employed at will. In California, you can still fire an employee for any reason, right? As long as it's not an illegal reason, right? So as long as you're not firing them because you're discriminating against them for any protected category, right, like disability, ethnicity, religion, sex, age, sexual orientation, you can fire them for you could fire them because you don't like the way their breath smells or you don't like the way they do their hair, as long as the hair is not related to any race or age, and as long as the breath is not related to any physical ailment that could be considered a disability. So I feel like I wanted to make a point that the disciplinary side of it, it's sort of, I feel like a lot of what we're talking about consistency, documentation, it's all sort of practices to help you prevent future litigation or to help when litigation occurs, to help facilitate like a quicker, more seamless process during the litigation.
Okay, great. Thank you so much for that. Yeah, we had several questions about that. Now, here's a different take on this. How do we document employee issues when they're a bad fit? You've hired somebody really not breaking a lot of rules. They're just personality-wise, they're just not fitting in. How do we handle that? Is that a disciplinary issue, or is that something else?
This is Maureen again. It can be a disciplinary issue in the fact of its behavior, and they're not treating their fellow workers correctly. They're exhibiting anger all the time, being rude. You have to be careful that you don't just document on personality. So when you document, you give the actual facts of what their behavior is and what it causes for others, how it's not part of the mission of your organization. Maybe you get them more, maybe there's training and employee assistance program. So you're going through some steps with them also and documenting that. You don't want it to go on for too long, but I don't think because I don't like the way you are and you don't fit in. That is very important, isn't it, for any organization? But I still say it's important to document that process.
Right, I agree. I think the fit thing is really difficult. I think a lot of times what happens is that discipline is applied sort of more strictly to people who don't fit in compared to people who do, right? And then that's perceived as favoritism. And if the person is not fitting in is a minority or a female or over 40 in California or is gay, then you have well, why aren't they fitting in, right? Is it because of their protected status, and is it discrimination? I would say it's very, you have to proceed really carefully with, because I think sometimes it could be when the fit is not working. Maybe they don't have performance issues, but maybe their managers just don't want to put them on they don't get preferred assignments, right? Because nobody likes to work with them.
Right.
And then that's when you're freezing somebody out.
Okay.
This is Julie.
Go ahead.
I'm sorry.
Go ahead.
Oh, I was going to say, I think sometimes too, I think those points are great. There's times we've had an employee that fit really well in one area of the company, maybe with direct client services. That grant went away. They got moved into, we tried to find them another position in the organization. They interviewed and got that job. Did not end up being a good fit in that department. So sometimes it is tough because, you really have to be able to ultimately point to the performance in some way, shape, or form, and that's tough if it's a bad fit. But you really should try to have some kind of documentation, or as Maureen mentioned, some additional training, something to try to correct those issues and be careful about how you do that, as Kai mentioned, if they're in a protected class.
Okay. And we have probably time for just one more. I don't want to have to cut anybody off, but an interesting question about the difference between verbal warnings and coaching. It sounds like that this employer kind of likes to go down the coaching route, but also wants to make sure that she's documenting it correctly in case there's disciplinary issues down the road. So can we talk about that a little bit while we in the next 2 minutes?
Yeah, this is Maureen again. I think that it is coaching. That's the way I look at it, even when you're talking to the employee verbally. That is the way you want to look at it. You want to find out why they are not performing well or what they don't understand. So you want to be that supervisor who coaches them well and puts a plan in place for them. I think for me, a verbal conversation is just something you're starting to notice and want to make that employee aware of. But I don't know, maybe I'm wrong. I just think the whole thing is coaching. That's the way you want it to come off. I'll let somebody else get in there and speak to that, but that's the way I feel about it.
All right.
Yeah.
This is Julie. I think we try to coach to start. If we've had some, what you might consider multiple coaching sessions with an employee and you're not seeing improvement, then that's kind of when it moves over to the verbal warning, which again, as Maureen said, is continued coaching, but it's like we've had this conversation and, we've tried to give you this opportunity to correct, and we're not seeing that progression. And so now we're actually moving to a verbal warning, which, is still an opportunity to correct. So, there's kind of a fine line. It's hopefully you're not going to just go straight to a verbal warning.
I like what Julie just said there. We talked about that. Really, you want it to just be a conversation initially. Sometimes just a pure conversation is going to change everything. And that's what you want. You don't want to have to start going through a process. Maybe just the conversation itself will be just fine.
Okay, excellent.
Okay, this is Kai. Yeah, I agree with Julie. I think Julie made a really good point about sort of the difference between verbal warning and coaching.
Okay, excellent. All righty, ladies. Well, thank you so much for your time today. We answered lots of questions, and I think we covered a very interesting topic, and I appreciate everybody's time. Also, if you attended, come back and join us next month at the end of March on the 28th. We had a request for, we did a recruiting webinar late last year. We had a request from attendees to provide a session on low-cost recruiting tools. We know that there's a lot of software out there and a lot of places you can go to find your next employee, but some of them are a little pricey. So we are putting together a specific program just for our nonprofit audience that will give you low cost or free, and we'll try to provide as many freebies as possible, tools that you can use when hiring your next superstar. But once again, thank you everybody for attending, and we will see you all next month. Bye-bye.